Good morning. This is Stephen Aquario, the Executive Director of the New York State Association of Counties, and we're pleased to present to you the New York State open government laws during the declared state of emergency. Of course, we're presenting this in the midst of the COVID-19 pandemic and providing another resource tool in partnership with the state of New York under the leadership of Governor Andrew M. Cuomo, the Committee on Open Government, assisting localities interpret executive orders, the Committee on Open Government providing feedback, guidance for local governments as they continue to work through government operations during the pandemic. There's been many questions that have been raised over the last several weeks about government operations, access to the public, how to engage the public and present things to the public throughout this pandemic. And the Committee on Open Government has been terrific in providing guidance. So we are pleased to present the Director, Shoshanah Bewlay, and the Director of Training, Kristin O'Neill, who will provide a presentation today. By way of background, the Committee on Open Government might be the most often utilized state agency for providing information and guidance to county officials from across the state. Their hardworking staff puts out countless opinions on local meetings addressing every issue that comes up, how to properly provide notice, take minutes, allow for public comment, leave for executive session. These are procedures we need to get right for the public. These could have consequences such as voiding a governmental action we seek to achieve if it gets wrong. When it comes to open government, the process we used is just as important as the policies we are seeking to pass. While we fight the COVID crisis, getting answers on how to properly conduct an open meeting has never been more important and most complex. In these times, it's vital for local governments to meet and act and help our residents, but how this can be achieved when public gatherings themselves can add to the health crisis. The governor's executive orders have given counties flexibility. We're grateful for the governor's leadership in this regard to achieve meetings while adhering to the principles of the open meetings law. It's really an honor to thank the local government clerks of the legislative boards, the elected officials, the supervisors at the town and county level, and the county legislators and county executives from the state who are admirably leading through this crisis. It's now my pleasure to introduce Shoshanah Bewlay, the Executive Director at the New York State Committee on Open Government, who has given us her time to walk through how to comply with this law during the COVID-19 crisis. Director Bewlay.
Thank you very much. My name is Shoshanah Bewlay. I am new to the Committee on Open Government, just appointed in the beginning of January. So I guess this is our first true test of the efficacy of this committee under new guidance and new leadership. But continuing her tenure as the Assistant Director of the Committee on Open Government and the Director of the Training and Outreach effort, joining me is Kristin O'Neill, and she has spent tons and tons and tons of time recently speaking to constituents, speaking to local government representatives, answering questions, and has put together a very, very useful deck of slides to talk to us about the changes to the law that we are most concerned about today with is the open meetings law, and to talk a little bit about FOIL and how FOIL responses may need to be thought about differently as we struggle to get into our primary workspaces and we work from home separate and apart from some of the documents that we are responsible for maintaining as open and public records subject to that law. So Kristin's going to take you through a presentation. Hopefully we'll answer and sort of anticipate many of the questions that you have. But of course, after the presentation, we'll be happy to talk with you about your questions and answer them. We also have been given a list of questions that we will hopefully answer in the presentation, and if we don't, call us out and we will definitely attempt to answer them for you at the Q&A portion. So Kristin, if you wouldn't mind to give us our training module on New York State open government laws during this COVID emergency.
Thank you, Shoshanah. So back in early March, when the coronavirus concerns, we were all aware of the concerns, but we were only just starting to think about how it was going to impact the open meetings law. We started getting questions from downstate, specifically like New Rochelle, Westchester County, how to comply with the open meetings law in light of the current public health concerns. So Shoshanah and I had to really start thinking very carefully about what type of advice we wanted to offer to the public. The Committee on Open Government does not have any legal authority to waive requirements of the open meetings law. So we wanted to balance the need for government transparency and openness to the public with certain very important need to protect public health and safety. So early in March, we started thinking about what informal guidance we wanted to give to the public, and then I think late in the day on March 12th, and it was actually published on March 13th, Governor Cuomo issued an executive order that suspended certain aspects of the open meetings law. Specifically, it suspended the aspects of the open meetings law that relate to in-person attendance at meetings of a public body that are subject to the open meetings law. So this was Executive Order 202.1, issued on March 13th. And it reads, Article 7 of the Public Officers Law, to the extent necessary to permit any public body to meet and take such actions authorized by the law without permitting in-person access to meetings and authorizing such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or listen to such proceeding and that such meetings are recorded and later transcribed. So that's a very long sentence, so we can break it down a little bit. In my mind, I'm gonna go back one slide here. In my mind, the aspects of the executive order have two important elements. One relates to how the public body itself can meet and constitute a quorum and gather for the purpose of conducting public business. And the other aspect has to do with the public's right to listen and or view the deliberations and decisions that go into a public body's determinations. So the first thing I point out is that Executive Order 202.1 did not prohibit public bodies from allowing in-person attendance at their meetings. It gave discretion to those public bodies to act in their constituents' best interests. So at that point, on March 13th, if a public body wanted to continue to have open meetings, it was free to do so. The executive order gave them the ability to hold remote meetings, but did not require them to do so if they wanted to conduct public business. However, as the pandemic progressed and the public health concerns increased, Governor Cuomo issued subsequent executive orders that directed that large gatherings of individuals be canceled. So non-essential gatherings, first it started out as gatherings of 500 or more, and then it was gatherings of 50 persons or more. And then as of, as of March 23rd, non-essential gatherings of any size for any reason were supposed to be canceled or postponed. So if you put together Executive Order 202.1 and 202.10, there you have the prohibition on holding in-person meetings of a public body of any size. So at that point, the public body, if it wants to continue to conduct public business, needs to hold their meetings remotely and comply with both the open meetings law as suspended by the executive order and any additional requirements imposed by the open meetings law. So what I'm going to do is work my way through the open meetings law and talk about all the aspects of that law that are impacted by the executive order. The first is right off the bat. You have the definition of what a meeting is under the open meetings law. It talks about being the official convening of a public body for the purpose of conducting public business, including the use of video conference for attendance or participation by the members of the public body. Historically, both the Committee on Open Government has advised and the courts have held the only way for a public body to conduct public business is to convene and meet in person or to meet via combination of being in person and via video conference. That was the only way that a public body could constitute a quorum, and that was the only way that a public body could conduct public business, is if they were all together in person or if they gathered through the use of video conferencing.
And that the video conference location was also open to the public attendance.
Correct. So EO 202 authorized meetings to be held remotely by conference call or similar service. So the order suspends the requirements of the open meetings law and section 41 of the general construction law that members of the public body be physically convened or convened by video conferencing in order to achieve a quorum and conduct the public business. By this executive order, teleconferencing is specifically permitted. Section 103 of the open meetings law has several sections, subsections that are affected by the executive order. The first is that it says every meeting of the public body shall be open to the general public. Well, they're still open in a non-traditional sense. They're still supposed to be open through a remote mechanism, but they are not supposed to be open physically for in-person attendance. 103B states that they're supposed to be held in facilities that permit barrier-free physical access to the physically handicapped. But under the executive order, they do not need to be held in facilities. In fact, if each individual board member wants to participate in a video conference from their own homes, they're free to do so. It does not need to be held in a single facility that can permit barrier-free physical access. In addition, I'm going to skip over C for a second and go to D. D requires that they are held in an appropriate facility that can adequately accommodate members of the public who wish to attend such meetings. Again, that's suspended by the by the executive order 202.1 because in-person attendance is no longer required. There's the right to in-person attendance at the meeting has been suspended, and so there does not need to be a facility that can adequately accommodate members of the public. And C requires that a public body that uses video conferencing to conduct its meetings shall provide an opportunity for the public to attend, listen, and observe at any site at which a member participates, which is what Shoshanah just mentioned a moment ago. Clearly, again, that's not the case right now under this executive order. So if each individual board member is sitting at home in their living room, participating in the video conference, they're welcome to do so. They count towards the quorum, and the public does not have the right to show up at that board member's home, knock on the door and say, hey, I want to sit in the living room with you and watch. They only have the right to remote access. The notice requirements of the open meetings law, there's no specific reference to the executive order about notice, but certainly from a practical perspective, there needs to be some changes to the notices. So sections 1, 2, and 6 of subsections 1, 2, and 6 of section 104 of the open meetings law require notice of the time and place of a meeting. And section 4 states that if video conferencing is going to be used, the notice shall inform the public that video conferencing will be used and identify the locations for the meeting and state that the public has the right to attend the meeting at any of those locations. These aspects are suspended right now in that 202.1 authorizes public bodies to hold the meetings without permitting in-person access to the meetings. The notice does not need to state where each board member is attending from, because for the very logical reason that the public doesn't have any right to attend at those same locations. If in-person attendance is barred by the public body in compliance with the order suspends the public body's obligation to identify the location from which the members are participating and suspends the obligation to state that the public has the right to attend the meeting at any of the locations. Instead of providing a meeting location in the meeting notice, again, this is not specifically addressed by the executive order, it's just practical advice, it makes sense. Public bodies should provide instructions to the public for remotely accessing the meeting through teleconference, video conference, webcast, broadcast, or other similar mechanism. If a public body is using GoToMeeting, WebEx, Zoom, any of those programs, the notice, instead of stating the meeting will be held at Town Hall, instead should say the meeting will be broadcast or webcast using this web address, or this is the way you can call into them and listen to the meeting. This is the way you can log on and listen and view the meeting. Gives the notice should give instructions to the public for how to remotely access the meeting while it is occurring. There is a section of the Open Meetings Law, section 104.5, that states if a meeting will be streamed live over the internet, the public notice for meetings shall inform the public of the internet address of the website streaming such meeting. This requirement is not suspended by the executive order. It continues, and public bodies should continue to do this. A couple of new requirements of the executive order that didn't exist in the Open Meetings Law. The public body must allow contemporaneous remote access to the public. So in other words, if you're having if you are meeting via teleconference or via web conference, whatever it may be, you must allow the public the ability to log on or call in. If you are holding the meeting and you are going to live stream it, you should provide the public with the address or the link, whatever it may be, for the public to listen to or view the live stream or broadcast, whatever it may be. There's an additional requirement that public bodies record and later transcribe their meetings. The transcription requirement has caused the most agita of all the obligations under the new executive order. Our advice from our office, and some of which has been confirmed, we do know that it must be a word-for-word transcription. That was the intent of the executive order. Minutes are not the same as a transcription. The public body still has an obligation to prepare minutes pursuant to the Open Meetings Law. But in addition, the executive order requires this word-for-word transcription. It does not have to be performed by a stenographer or a professional transcription service. It can be performed by an employee, or several remote access services such as WebEx and Zoom and things of that nature actually will also will create a transcript of any recording that it prepares. So those are ways of preparing a transcript that may be less labor intensive than having an employee do it themselves. However, a transcript performed by an employee is also permissible. There is no time limit for preparing the transcript. In our view, this does not need to be an immediate obligation. We understand that all government agencies and public bodies right now are working with reduced staff under significant stressors, and preparing a transcript may not be an immediate priority, and we understand that.
Kristin, can I add that one of the questions that we have had from several localities is on this time limit issue is, as long as you keep the recording, you have the ability to prepare a transcript whenever it may be needed, such as if somebody files a FOIL request seeking the transcript, or if a constituent calls your office and says, I missed the meeting, can I get the transcript? I don't have the ability to use my internet connection to view it, the recording. So that may be a trigger for you to prepare the transcript either by that service that has the automated transcript preparation capacity, or having an employee go through and from the recording prepare a transcript.
Thanks, Shoshanah. Yeah, there are other services. I've been told by several people that, for example, like Zoom specifically, I know that it will prepare a transcript. I've been advised that it's not the best transcript, but it's a transcript. If a public body is looking for other services, just do a little online research. I think there are several entities that will prepare an automated transcript of a recorded meeting. Some of them that, not that I'm advocating for anything, but I think there's something called otter.ai that is fairly inexpensive. But certainly we just don't want this transcription obligation to become an onerous burden on public bodies. The staff of the committee have recently prepared 2 advisory opinions regarding the effect of Executive Order 202.1 on the open meetings law. If you'd like to take a look at those advisory opinions, they're available on the committee website, and they address how the executive order affects the ability to obtain a quorum, and it affects the requirement for contemporaneous remote access by the public in lieu of in-person public attendance. So it just addresses several of the very basic issues and questions that we've been repeatedly hearing and receiving. So the one other thing that I want to go quickly look at some of the questions that came in, and I want to make sure that we address them. One has to do with the expiration of Executive Order 202.1. Originally, it expired, I believe, the original expiration date was supposed to be April 11th, and then Executive Order 202.14 extended the expiration through, it extended the application of 202.1 relating to the open meetings law through May 7th. So that's the current expiration date of 202.1's, the order specifically relating to the open meetings law.
And you should expect that the governor will very likely extend so that it's coterminous the 202.1 suspensions through some future date, because subsequent executive orders to 14 have extended certain provisions out farther than May 7th. So I think at some point we'll see another catch-up provision in an executive order that may not specifically talk about the open meetings law, but that will further suspend those requirements that were addressed in 202.1 at some future date.
Thank you. Yeah, as for an example, I think someone brought to our attention the fact that 202.15 actually established a new executive order specifically relating to public hearings, whereas 202.1 related to meetings. And the open meetings law governs meetings of public bodies. Now, public hearings are often meetings of public bodies, but they are also governed by several other statutes that, so when we receive questions about, well, can we hold a public hearing pursuant to Executive Order 202.1, my advice was you want to make sure that you're complying with both the open meetings law as suspended by the executive order and any other statute that may apply. Executive Order 202.15 stated that public hearings that were supposed to be scheduled for the next couple of months could be postponed until after June 1st, or they could be held remotely. So a later executive order specifically applied to hearings as opposed to meetings. So the question that was posed earlier was which expiration date applies. Currently, right at this moment, the open meetings law suspension, the expiration date is May 7th, but as Shoshanah noted, we anticipate it being extended, and the executive order relating to public hearings being able to be held remotely at this moment expires on June 1st. Just want to make sure, as I'm taking a glance, make sure, I think I've addressed the questions that were presented to me, so I wanted to move on and take a quick look at the Freedom of Information Law. We are also getting quite a few questions about how to comply with the Freedom of Information Law in light of reduced staffing and executive orders that non-essential staff not be present in the offices, in the public buildings. So of course, the intent of the Freedom of Information Law is that the people's right to know the process of governmental decision-making and to review the documents and statistics leading to determinations is basic to our society. Right now, however, there's a lot going on that makes access to these records more difficult. And through no fault of their own, public agencies, government agencies, municipalities, counties are faced with difficulties in complying with the Freedom of Information Law in the same way that they would have a month or two ago. None of the requirements of the Freedom of Information Law have been suspended by executive order at this point. I don't know if Shoshanah, you have any insight here, but my expectation at this point is that it probably will not be. If it hasn't yet, it probably will not be.
I think that's right. I know that there was a consideration about it, but I think that they were focused on things that required that were physically in person. So they stopped at the open meetings law and didn't proceed down the path to FOIL, which is just made more difficult. But nobody expects necessarily to come and examine documents at this point based on other executive orders that have been issued. So again, Kristin's right. At this point, I don't think that FOIL continues to be on the radar of the administration for potential suspension by executive order.
Thank you. So our advice has been to use your best efforts to balance the health and welfare of government employees with the need for public accountability. I think it's just about using logic and common sense and doing the best we can under the circumstances. For example, if you have a records access officer, if you have someone who has been designated to coordinate the Freedom of Information Law responses and they're working from home, hopefully they have remote access, that they can, any Freedom of Information Law requests that are coming in via email can be acknowledged via email by the records access officer, even if they're working at home. And then hopefully even then, if possible, that records access officer or the coordinator can start the process of gathering the records. They can send out emails to the appropriate departments, to the appropriate staff members, and see if they can start gathering the records. Of course, you may not have, if these records only exist in physical form, or they only exist on networks that are not available remotely, there's going to be a delay, and we understand that. In our view, New York State on pause is certainly a factor that can be considered when determining whether a response date is reasonable. Under the Freedom of Information Law, there's sort of a couple of important dates to remember. The first 5 business days. Within the first 5 business days, an agency such as the county is required to do something, either provide the records sought, deny access to the records sought, state we don't have the records, or state we acknowledge receipt of your request, but we need more time. Generally, under those circumstances, it's been our opinion that the date by which the county plans to respond in that acknowledgement letter, that's the date that is provided by the county, for example, should generally not be longer than 20 business days. That's under normal circumstances. But even under normal circumstances, there are times when an agency is going to need more than 20 business days to respond to a Freedom of Information Law request. And the law gives an agency the ability to take more than 20 business days as long as they provide a date by which they plan to respond that is reasonable under the circumstances. And if they're going to take more than 20 business days, the agency is required to give a reason for the delay. Well, as I said, New York State on pause is certainly a factor that can be considered when determining whether a response date is reasonable, and is certainly a factor that would cause a reasonable delay in responding to a request. So if you need to, at this point, provide a date that you plan to respond that is longer than you would normally provide, that is further out in the future than you would normally state, that's reasonable right now. So that's how an agency such as a county may be able to handle requests that are coming in via email. Of course, sometimes people still like to use the mail. You've got Freedom of Information Law requests that are coming in through snail mail. If the records access officer is working from home, but other agency staff are physically present in the agency offices, it would be good if the staff could, if possible, scan copies of the FOIL request to the records access officer for processing. And then the records access officer can do the same thing from home that they would have otherwise done from the office. If there's no staff physically present in the office, for example, this is me right now, I've been the staff member that's been designated to come into the office a couple of times a week just to check on, to gather mail, Committee on Open Government mail, and I scan the mail and send it out to Shoshanah and our huge other staff, which is our administrative assistant. And we'll review the mail and take whatever actions are necessary based on the incoming mail. I come in twice a week, but I would say a minimum of once per week would be ideal. Is that if somebody is coming into the office to gather mail once per week, that's going to allow the records access officer to acknowledge requests within 5 business days. Say someone comes in on a Wednesday, they get that mail scanned out to the records access officer, they can acknowledge the request by the following Wednesday, which would be 5 business days. And finally, if all employees are prohibited from entering agency office space, it's our opinion that the request can be considered received at the point which employees are permitted to re-enter the space. So if someone sends a Freedom of Information Law request by snail mail, and for whatever reason, all employees have been ordered to work from home and not present themselves at the office space, it is our opinion that the Freedom of Information Law request was not received until staff was permitted to enter that building. My opinion is, our opinion is that if this is the case, if this is what is happening with your agency, I think in agencies such as a county, it may be less likely, but if that's the case with your agency, it would be very wise to let the public know that this is the case, that any FOIL responses sent by mail during that period will not be acknowledged on the prohibition until the prohibition ends. And that a notice to that effect should be posted on the agency website. Keep the public informed, let them know what's going on. That's our advice. And finally, I just want to remind everyone that our office is still available. Even when I'm working from home, you can call our office phone number. I will get the call if I don't pick up. Please feel free to leave a voicemail message, and you're always welcome to email myself either directly or our office account, which you'll see up on the screen right now. All right, thank you.
Thanks, Kristin.
If you have any questions, please take some time now to submit those questions in writing, and you could do that on the right side of your participant panel. There should be a box for questions. If you submit those questions, we will take them in order of reception. The first question we had during the presentation, Kristin and Shoshanah, is how do we conduct public hearings? And I know we talked before the presentation that this presentation was about public meetings. Do you have any advice for how county boards can run a public hearing?
Well, Kristin did talk a little bit about this, but Kristin, why don't you reprise what you were discussing about the difference in the laws that you have to comply with if you are conducting a hearing within a meeting?
Okay, so first, there are aspects of a hearing where the open meetings law apply, because generally when you're having a hearing, you have a county legislature or a board of supervisors that is conducting a hearing, is generally a quorum of the legislative body that is gathered together for the purpose of conducting public business. So in addition to it being a hearing, it's also a meeting. So you need to comply with the requirements of the open meetings law. So in other words, you need to notice it to the public. You need to provide remote access pursuant to 2021. But in addition to it being a meeting, there are certain other statutory requirements that are going to apply. So you want to take a careful look at those statutory obligations, which I have to be perfectly upfront about. I am not overly knowledgeable because there is a different statute for every different type of hearing. There's no just one general, as I'm sure the people listening to this are aware. There's no one public hearing statute like there is an open meetings law. There is no public hearings law. It's the statutes governing them are in town law, village law, county law, second-class city law. It's all over the place, general municipal law. So you need to take a look at the specific statute that governs to make sure that you're providing appropriate notice, and that whatever the rules are for accepting public comment that are set forth in the statute, you want to make sure you're complying. If the law is somewhat vague on, it just states you must receive public comment, but doesn't really specify how. Pursuant to 202.15, which is a fairly more recent executive order, the governor's office has clarified that you can go ahead and have those hearings remotely, but then you need to make sure you're establishing in the best way possible, in the most open way possible, ways of allowing the public to give you their input. Ideally, if you're having a hearing, in our view, you should be giving the public that remote contemporaneous access and allowing them to comment during the hearing. That would be ideal.
Well, certainly if you have a quorum of your body there, you must.
Right, yes.
So it's again, the interconnectedness of these two areas is profound. And if anyone runs into any tensions between the requirements of 202.1 and the requirements of 202.15 and whatever statute it is that is governing your public hearing, your specific public hearing, that's probably ripe for a note over to us or to the governor's office to describe the tension so it can be addressed. Again, as I mentioned before, it is very likely that executive orders affecting hearings and meetings will become coterminous at some point. Right now, they expire at different times. And so if there's any catch-up provision required to make those two topic areas coterminous, those suspensions coterminous, the governor might have the opportunity to address any tension that is discovered.
In addition, I think allowing for written comment, providing sufficient time, maybe longer than you might normally provide for the public to either email or mail their written comments relating to the issue. You just want to make sure you're giving the public as much opportunity to provide their input and feedback on the issue as possible to make it similar to what would have occurred if we were operating under normal circumstances.
Thank you very much. Stephen, do you have a question for Shoshanah or Kristin?
Thank you, Mark. Shoshanah and Kristin, if a lot of questions that we got throughout the period of time here concerned the transcript and the verbatim nature of the transcript. And the question was centering around if prior to the executive order, the use of video conferencing was permissible, which it was, and there was no need to provide a written transcript as long as that video recording was put up on the county's website. The question came in during the COVID pandemic period after that suspension on March 13th, it looked as if the executive order authorized the use of telephonic with the verbatim transcript. So it became confused if you did it by video and posted it, with the public able to see and hear all of the votes and the actions taken, why would a verbatim transcript of that video recording be required? So that's my question.
So I spoke to the governor's office about this because we received this question from a number of folks, because it seemed that the executive order was imposing an additional requirement on public bodies, especially those public bodies who routinely posted archived video, full video presentations of their open meetings. And the confirmation was that notwithstanding the requirements or the pre-existing practices of any particular public body, that a transcript was required. And again, so even if you had been routinely posting video, the idea was some people don't have the ability to use the internet to go and view those videos, but that many people may request a transcript and read it later. So I think that it was meant to be as transparent as an attempt to continue to retain as much transparency over public meetings and open meetings as possible, while we were restricting people from attending in person who might not be able to use the internet to attend.
Thank you.
Okay, thank you very much. I was told, this is a question that came in, I was told by an attorney that if we had any type of meeting that we could not have any board members in Village Hall, even if we were meeting with others remotely. I was told if anyone is in the office, including the clerk, then you have to allow the public into the building to attend the meeting.
Not true.
Agreed.
Okay, thank you. Will we be able to print this out for future review? Yes, as I indicated, we will have the slides available on our website following this presentation. May local government bodies meet in person should they desire to, and is it size dependent?
I think taken together, all the executive orders would say no. You can't do that. Unless,
I would say
I guess,
particularly a body the size of a county legislature or board of supervisors.
I mean, I think if we're talking fewer than 5 people, that it may be possible with social distancing, much like the governor's press conference, which is starting now, early today. And so that I think that might be permissible, but a body of any size that's relevant to this audience, very unlikely that that would be permitted.
Okay, thank you. One more question again on the transcript. We don't need to provide a transcript unless it is requested, right?
Right. But you should retain the ability to make one, because the governor's executive order requires that you have one if you need it. It doesn't say when. So all the meetings that were held during the declared disaster emergency, my best advice would be retain those videos, retain the ability to have them transcribed if the need for them arises.
Great, thank you. Do you have to afford, or do we have to afford the public the right to speak during the meeting?
No. Not unless
Another
your
question.
specific bylaws require that. Or, Kristin, am I wrong about that?
No, that's what I would say. And generally, often public bodies have policies that allow for public comment. In my view, if for particularly if the technical aspects of providing for public comment is difficult, would be very difficult. I think a public body could pass a resolution suspending public comment for certain aspects. I think it just depends on your technical capability, but there's nothing in the open meetings law that requires a public body to afford a time for public comment or public participation.
Okay, thank you. How should we handle executive session?
I think it's going to come down to the technical aspects. So let's say, for example, you're using a program such as this, like a GoToMeeting or a Zoom or a WebEx. If you just need to do a little research and figure out what options are available to you. Are there breakout rooms? Do you need to perhaps step away from the primary meeting and mute your microphones from the primary meeting and establish a secondary meeting that is just for the public body? There's certainly ways to do it. You just need to figure out the technical aspects of it. You certainly can continue to enter into executive session. You make your motion to enter into executive session during the open meeting, and then the public body just has to establish sort of a private room, so to speak, for having that conversation, whether that's a separate teleconference call, a separate breakout room on the remote access service. There's ways to do it. It's just that a little research may be necessary to figure out based on what program you're using.
It is just important to note that the requirements for establishing the executive session still are in effect. They're not suspended by the executive order. So it does present those logistical obstacles, which many of these platforms do allow you to overcome, but it's a little awkward. You know, instead of having people hanging around in a room waiting for you to be done with your executive session, they're sort of looking at a screen that says, "We are in executive session, please stand by." And it may last for however long it lasts. But again, a lot of these platforms do offer appropriate mechanisms to allow you to have a private secondary meeting.
Great, thank you. Can the public notice indicate an email or person's contact info for the instructions so that the public meetings are not Zoom bombed by publicly advertising the connection info? Then when the public contacts the person at the agency, they can then be given registration information for the Zoom. Is this acceptable instead of the public notice giving specific sign-on or login information?
And Shoshanah, feel free to weigh in too, but my feeling is I have concerns about this because I have concerns about, for example, if you have a 7 p.m. meeting and at 5 or 6 p.m. somebody decides they want to go to, or at 6:55 p.m. decides that they want to access the meeting, are they going to be able to by emailing someone? Will somebody be like instantaneously responding to those requests for logon information and passwords? And people that are not necessarily like, so for example, you have people that don't want to use the internet access but instead want to call in. Is there going to be a way for them to access that information? Will somebody be responsive to requests for call-in information instantaneously? I have significant concerns. I understand there's been a lot of media coverage of the Zoom bombing, but I think if those public bodies maybe take a step beyond that and do a little bit more research, there are ways to protect the meeting from those.
Some of those ways to protect the meeting. Yeah, Kristin, some of those ways to protect the meeting, though, are equally concerning because you don't want to put the public body in a position of moderating who can join either. You know, even someone with a crazy email address that they've never heard of should be able to join, or someone who identifies themselves, as Peter Pan or whatever. So it's a tricky situation, the security of these meetings. I don't know the answer. But I share Kristin's concerns, but I also understand the desire not to be Zoom bombed As a parent, I so understand it. And so as a public body member, participant as well, I don't want to have those distractions in my meetings. So I guess people should use their best judgment. If they think that they can provide access to everyone who legitimately wants it through the use of a moderated provision of passcodes and access information all the way through the meeting. So that means somebody sitting there at 7:02, at 7:05, at 7:55, if the meeting is still going on, for people who may want to tune in at that time, and you feel like you can keep up with that volume, that could be an opportunity. But keep in mind that even someone who you don't think has a legitimate interest in the meeting, who emails that email address to ask for credentials, is going to have to get them.
Right. So I mean, I think it'll cut down on the spontaneous Zoom bombing. But a couple of things that I'll suggest specifically relating to that program is, one, you're going to want to have somebody assigned to moderate the attendees. You want to make sure everybody is on mute. Not that they can't take themselves off mute, but at the beginning of the meeting, you tell them, we need everyone to stay on mute. If you take yourself off mute and start talking, we're going to disconnect you and you will be unable to reconnect. I think that's reasonable. If you disrupt the meeting, just as if you disrupted a meeting in person, we can ask you to leave. And I think that would be permissible. In addition, there are ways to prevent attendees from having control over the screen. I think one of the problems with Zoom bombing were showing inappropriate images on the screen. You can have the settings so that only the person who is presenting has the authority to screen share. Those are a couple of settings that I would suggest.
That's a good idea, Kristin.
Okay, great. Thank you. Very good ideas, good advice. We have a question on, there's a little confusion about in-person meetings. So a town board can be relatively small, under 5 people, and they could have the ability to be socially distant during those meetings. So the question is, can we still conduct those in-person meetings if those meetings are small? Are town boards prohibited from having normal open meetings at this time?
Where the public attends, I think that there would be probably a number of problems with having people other than the members attending the meeting. If 3 people want to sit 6 feet apart from each other and have a meeting that's video broadcast to the public, that's probably going to be permissible. If you're talking about a meeting where you have those 3 members and 25 members of the public showing up at the town hall, then that's a problem. So the difference between having the members be together but socially distanced, and the members of the public attending in person, I think that's where the problem arises. Kristin, why don't you chime in if you have a different view?
No, agree entirely.
So I guess the bottom line is, if you have a small enough group of members, you can probably get together 6 feet apart in a location, but you probably cannot invite the public to be there in person.
Okay, great. Thank you. Can voting by video conference occur at town board meetings?
Yes.
Yes. I think they can, the town board members or any member of a public body, as long as they're in compliance with the open meetings law as amended by the executive order, they can participate and vote just as if they were physically present.
Okay, great. So I think, what about holding bid openings? This is a question that just came in. bid open.
Not my area of expertise. I don't know.
Right, unless you have the whole town board there and the purpose is to do something. I don't think that's conducting the public business until you're deciding on the bid. So I don't know if it's covered by the open meetings law.
Okay. Can they vote using, or can a board vote using a phone conference?
Yes.
Yes.
Super important though to have somebody like the board secretary or someone in an administrative capacity, making sure that if you can't physically see someone voting or it's not the raising of hands, that somebody's recording carefully who is placing what vote.
That answers the next question.
Roll call voters.
Roll call vote,
right.
exactly.
Right. So there would need to be a roll call vote. That answers the.
That would be
question.
a safe way to do it. I mean, that's certainly one. That puts the period on the sentence there.
Okay, I think that will conclude our Q&A session. I want to thank both of our panelists today for taking their time and using using their expertise to update our membership about the open meetings law during COVID-19. Panelists, do you have anything that you want to add before we conclude today's webinar?
Just want to say what a pleasure it was to be invited to do this. Thank you so much for this opportunity. And please, as Kristin said, anyone can contact our office. Please do so. And if you have any questions at all, or if we've confused the issue at all for any of you, please send a follow-up question to us or to Jeanette or any of the other organizers of this great panel. And we will be sure to try to clarify any remarks.